Okay. Good afternoon, everyone, once again, and thank you for joining us. My name is Davina Gownden, and I'm one of the communications advisors at RPRA, and today I'll be moderating today's session. So welcome to the joint Deloitte-RPRA webinar on the Ontario Electronic Stewardship final wind-up steps and residual fund disbursement, hosted today on April 10th. Today's webinar is going to give you an update on the OES wind-up steps, and we'll also be answering your questions. We will stop at the end of the presentation for questions, but feel free to add them to the queue during the presentation. To ask a question, you can click on the Q&A tab, type it in, and click send. If you have any questions after the presentation for RPRA, please email us at communications@rpra.ca. Just a note that this webinar is being recorded and will be posted to our website later this week. I'm going to hand it off now to my colleague, Cameron Perrick, to introduce the rest of the presenters and start today's presentation. Thank you.
Thanks, Davina. Welcome everyone to the session. My name is Cameron Perrick. I'm Director of Programs and Stakeholder Relations here at the Resource Productivity and Recovery Authority. I'm happy to welcome Rich Williams, Senior VP of Deloitte Restructuring, speaking on behalf of the appointed OES liquidator. We're also joined by Virginie Gauthier, partner at Gowling, and Michael Busman, partner at Gowling, who are legal counsel to Deloitte Restructuring, who are going to be able to answer any granular questions around the CRA tax case, if there are any from the group here today. So just a little bit of roles and responsibilities here. This is a joint session. This is a Deloitte's opportunity to provide an update on the status of the windup and the status of the remaining CRA case, and they'll be able to answer questions related to OES's liquidation and operations. And RPRA representatives, myself and Davina, are here if there are any questions specific to the history of how we've gotten here in terms of Minister directing the wind-up, approval of the wind-up plan itself. So that's how we'll be directing the questions if there are any in the Q&A. So with that, I'm going to hand over to Rich, who's going to walk this group through the presentation.
Thanks, Cameron. So happy to be here, give everyone an update on where we are in the liquidation, and more importantly, I think, on the outcome of some of the conversations we've been having with CRA around some of the HST issues. Davina, if I could ask you to advance the slide. So I'm not going to go through and read bullet for bullet on this deck, but we'll go through and give you a high-level summary of where we are. The liquidator will be posting a copy of the deck that's on the screen now to our website, and I understand RPRA will also be posting a recording of this session. So if there are any questions after this, if you read through things and you've got questions, there's contact information available for the liquidator on our website, and certainly feel free to reach out. So briefly, by way of background, the story started back in 2018 when OES was directed by the minister to wind up the Waste Electrical and Electronic Equipment Program. As a result of that process, Deloitte was appointed as a liquidator, first privately by resolution of the board of directors in April of 2021. And then shortly thereafter, in June, that appointment was affirmed by the court. So our role from the outset has been to realize on what assets OES has, settle its financial obligations, implement the plan, and take whatever ancillary steps we need to wind down and dissolve OES as a corporate entity. The lion's share of that work was completed in 2021. OES didn't have much in the way of physical assets for us to realize on, but we did run a claims process to identify and extinguish all of the financial obligations. One of the things that came out of that initial work that was done back in June and July was an identification by the liquidator of a potential claim against CRA in respect of over-remitted HST. So we pursued that with the help of Gowlings and have been successful in securing a refund of approximately $15 million, with some more money still to come, but we'll get into that in a moment. Davina, could you advance the slide, please? So a little bit of background on the plan itself. OES prepared the wind-up plan back in 2018. Plan includes a couple of key provisions, one being the elimination of steward fees back in 2019. That was in result of a windfall that OES received from CRA in terms of HST. And then the other big point is the transfer to RPRA of residual funds remaining after we've settled all of OES's obligations. When it was drafted, the HST claim hadn't been identified. And so the wind-up plan at that point estimated a transfer of approximately $3 million. As we'll get into later in this presentation, we're now looking at close to between $17 and $18 million that will eventually be transferred over to RPRA. Davina, could you advance that, please? So when we came in, OES had approximately $4.5 million on hand. Part of that went to pay professional fees, RPRA's fees, and other ancillary costs that have been incurred over the course of the administration of the estate. And again, this is just touching on the HST claims that we have filed. I won't get into the numbers here because I want to explain what that claim was about before we do. So Davina, go ahead and advance, please. So the meat of why we're here is really this HST claim, and I'll do my best to provide a high-level summary of it. In case anybody does have any specific technical questions on the HST issue, Michael Boosman of Gowling's tax group is here and can answer any of those. So back in 2018, Tax Court of Canada awarded a decision in favor of OES, which resulted in them receiving just over $60 million of previously denied input tax credits. Because OES operates on a cost recovery basis and funds its activities through the EHF, that surplus put OES in a situation where it could eliminate the EHF and fund its operations from that $60 million. So over the course of time between 2019 and 2020, stewards did not pay any EHF, and OES funded its operations by drawing down on that surplus. At that time, though, it did receive advice from its tax advisor that even though it wasn't collecting HST, it should still be remitting notional HST on the steward fees that were being paid by that $60 million. The liquidator reviewed that, disagreed with the tax advice, and determined that OES was entitled to recover those funds from CRA. So over the course of the last few years, among other things, we filed 2 amended HST returns with CRA. The first was assessed by CRA last December, and in January, we received a refund of approximately $15 million. The second return, which is still outstanding, should result in an additional refund of about $600,000. The audit on that return is still ongoing, but based on communications we've had with CRA, we're reasonably confident that we'll have that money in the next couple months. Davina, if you could advance, please. So the OES's audited financials at December 31 reported assets of $17.6 million, including just over $2 million in cash, and then the $15 million the HST refund that was eventually received in January. We expect that once we receive the additional $600,000 and incur our costs to close out the administration, that the final distribution to RPRA will be in the range of $17 to $18 million. There's a number of factors that could impact that amount, one being CRA's assessment of the amended return, the second being the amount of time that CRA takes to issue that amendment. The estate incurs kind of regular ongoing costs relative to its administration, so the longer this drags on, the more funds are spent that way. And finally, it be influenced by the liquidator's ability to secure court approval for certain steps to wind up and dissolve OES, including that final distribution of RPRA as required by the wind-up plan, filing final tax returns, and getting the orders necessary to dissolve OES and amend certain regulatory notice deadlines. Could I have the next slide, please, Davina? So once we have the assessment from CRA, next steps will be to go to court to get an order, first of all, approving the distribution of funds to RPRA, less a holdback to cover expenses to finalize the administration of the estate, and then discharging Deloitte as a liquidator once we file a certificate attesting that we've done all the steps required to wind up and dissolve OES. From there, we'll go to arrange for final tax returns to be submitted, send a report to RPRA and to the minister, setting out the steps taken to implement the wind-up plan. And then once the minister has that final report and has issued a notice terminating the program, we can remit any balance of the holdback to RPRA and close off the estate. So I'm pretty sure, Davina, if you could just advance the slide, that's all we have for you by way of an update, and we're prepared to answer any questions you might have.
Thank you, Rich. So I don't see any questions in the tab right now, but we'll give folks a couple of minutes to gather their thoughts and add some questions in. Perfect. We have our first question. So how does the OES situation relate to the other wind-up for paint or packaging, etc.? Anything to still learn from the other programs? Cam, I'll hand that one off to you.
Yeah, thanks for the question, Sheila. In terms of learnings, I think through the wind-up of let's focus on the paint, which would be the MHSW program, wind-up and termination. SO, the corporation was obviously not liquidated, so there wasn't a roadmap that was created through the process of the termination of the MHSW program. So if Deloitte isn't, or if OES is indeed the first program to be wound up and liquidated in full, that would be, you know, we would be actually applying some learnings from this process to the other IFOs that would subsequently be liquidated, so OTS and SO. In terms of how, say, reserve funds were dispersed, each of the program windups were subject to you know, varying directions from the minister. So in the MHSW program, those funds were returned to SO, or sorry, returned to as fee reductions via SO, or through fee reductions offered by the ISOs. So again, a very different situation. But I'm not sure if there's any specific elements of program windup that you're interested in, how we may apply or not apply to this situation, the windup of the WE program, that would be helpful.
Thanks, Cam. I have another question. So will the setup of competitive pros run into the same problem with HST as OES?
I don't think that's a question for Deloitte, that's for sure. I'm sure the tax lawyers have some thoughts, but I don't think it's their place to comment on the proactivity. I think that would be a question for the pros themselves. That Sheila, you could ask them directly how they plan to manage their tax filings.
Thank you. And Cam, another question for you, or anyone on the call. Has the RRCEA changed the rules on HST? So the regulation itself.
I don't know how to answer that question, other than, if you have any further, I think that would be outside the scope of this information session. But Sheila, please feel free to send me a message and we can pick it up offline. But I do believe that it's out of scope of this session related to the status of a wind up of a WDTA program.
Okay. If there's any more
But
questions.
thank you for those questions. They're good things to be thinking about, just slightly out of scope of this session.
Mhm. We'll give a few more minutes if there's any questions about the HST claim from Deloitte, RPRA's role. So another question from Sheila around the timeline. Do we have a best estimate for the wind up and when these activities are expected to be completed?
I think
Yeah, I
that's
think I can
a
take
question
that.
for Rich. Yeah.
Yeah. So assuming that we get the final refund from CRA relatively soon, there's no reason that we wouldn't be able to wrap this up by the end of the calendar year.
Thanks.
I think thanks, Rich. There's also, there are things within the control of the liquidator and reporting to the court and seeking discharge subject to certain steps being taken, as one of the steps, including submitting a final report to RPRA and the minister, and subsequently the minister issuing a letter terminating the program, and the timing of which would be at their discretion when they've done their due diligence and feel they can confidently issue a letter of termination. Again, the timing is subject to the ministry's discretion.
Okay, I'm not seeing any more questions in the queue, but just a reminder to the group that this session is being recorded, and the recording along with the slides will be available on RPRA's website by the end of this week. If there are no other questions and any comments from the team before we close out?
Yeah, Davina, I just wanted to note if folks on the call do have any questions, I know Rich noted how to submit questions into to Deloitte Restructuring, the OES liquidator, but if there are any questions to be submitted directly to RPRA about the wind up, please do so through communications@rpra.ca. We'd be happy to talk you through anything you need to about the wind up process.
Yes, perfect. Thank you so much, everyone, for joining us, and we hope that you have a great day. Thank you. Bye.
Thank you.